vengeance, but of justice. It's in that spirit that Algeria repeats the request made in its previous submissions. Thank you, Mr. President, members of the court.
I would thank the Algerian delegation.
Participating delegation, Saudi Arabia, to address the court. I call upon His Excellency Mr. Ziad Al Atiyah to take the floor.
Members of the court, it's a great honor for me to appear before you to present my country's position on a matter of utmost importance of all states and the United Nations. In my remarks today, I will expand on a few critical points made in our written statement and address at the outset one matter that postdated our submission, but which is impossible to ignore when considering the questions before the court. That matter is, of course, Israel's military aggression against Gaza and its increasing acts of violence directed against the Palestinian population of the West Bank, including East Jerusalem, since October 2023. I believe I speak in consonance with virtually the entire international community in expressing the kingdom's profound revulsion and condemnation of the horrendous death, destruction, and displacement of Palestinian civilians brought about by Israel's illegal and brutal war in Gaza and the notorious increase in Israeli aggression, impunity, and international law violations in the West Bank, including East Jerusalem, since October 2023. Israel defends this obscene brutality as the necessary price for defeating Hamas. The Kingdom of Saudi Arabia firmly rejects this twisted logic. Israel's actions in laying waste to the Gaza Strip, killing and maiming tens of thousands of innocent civilians, depriving them of food, water, and the basic means of survival, while displacing virtually the entire population of the 2.3 million people, are not justified under any circumstances. Israel's actions have severely dehumanized the Palestinian population, treating them as dispensable objects rather than human beings. These disgraceful acts, which have brought about formal accusation before this esteemed court that Israel is committing genocide against the Palestinian population, as well as an order of professional measures recognizing the plausibility of those accusations and ordering Israel to comply with its obligations under the Genocide Convention, necessarily weigh heavily up in the consideration of the questions before the court in this proceeding. For if nothing else, they demonstrate all too vividly how the illegality of the Israeli occupation over more than 5 decades can degenerate into the ugliest of consequences. A final point I wish to highlight at the outset is that all written statements submitted before this court, not one state has sought to defend the legality of Israel's policies and the practices in the occupied Palestinian territory. This is a telling acknowledgement of the international community's unanimous recognition of the illegality which pervades that occupation. Israel itself does not attempt to defend the substance of its policies and practices. As the court will have observed, its 5-page submission does not, no doubt because it cannot, say anything whatsoever about the substantive allegations made against it. Instead, it focuses almost entirely on why the request of the advisory opinion and the questions contained therein are somehow improper. The only logical conclusion that can be drawn from all of this is that Israel's policies and the practices in the occupied Palestinian territory are legally indefensible. This brings me to the next part of my statement. The Kingdom of Saudi Arabia submits that the court has jurisdiction to issue the opinion, and there are no compelling reason for it not to do so. To the contrary, given the recent increase in bloodshed and destruction by Israel in the occupied Palestinian territory, as well as the dangerous statements made at the highest levels of the Israeli government, we respectively submit that the court is under a duty to issue its opinion. I will now discuss the arguments advanced by some states that the court should not issue the opinion for two primary reasons. First, because the opinion might prejudice a negotiation process aimed at resolving the Israeli-Palestinian conflict, which those states consider to be ongoing. And second, because the questions posed concern a bilateral dispute between Israel and Palestine. Not only are these arguments misguided, but they have been repeatedly rejected by this esteemed court under highly analogous circumstances, including in the World Advisory Opinion. The Kingdom regards the first argument as being based on a blatantly false premise and devoid of any legal foundation. Its lack of legal credibility has been addressed by the League of Arab States in its October 2023 comments. In the interest of time, I would respectively direct that the court's attention to those comments, which we fully endorse. Simply put, the court's prior practice should prevail in this instance. The practice gives deference to the General Assembly when requesting guidance from the court an issue the Assembly considers irrelevant to its work. As the following demonstrates, the assumption that a serious negotiation process exists is a fiction that offends reality. In the 2004 World Proceedings, the Kingdom of Saudi Arabia described Israel's modus operandi in the occupied Palestinian territory since 1967 as, quote, deliberately enhancing its position and changing the territorial status quo to its benefits, end of quote. The court rightly recognized this reality in its advisory opinion, referring to the illegality of Israeli settlement practice in the occupied Palestinian territory. The court also warned, quote, the construction of the wall and its associated regime create a fait accompli on the ground that could become permanent, in which case it would be tantamount to the de facto annexation, end of the quote. This assessment was precedent and tragically, but predictably, resulted in no change in Israel's illegal conduct. Now here is this seen more clearly than in the number of legal settlers residing in the occupied Palestinian territory, which has grown from roughly 424,000 in 2004 to some 700,000 settlers today. Since 1967, far from engaging in negotiations, Israel has made it virtually impossible to establish a cohesive Palestinian state. It has done so by annexing more than 2 million dunams of land, building more than 279 illegal settlements throughout the West Bank, illegally annexing East Jerusalem and declaring Jerusalem as its undivided capital, confiscating natural resources, demolishing Palestinian homes, and much more. Those actions are well documented in the many UN reports discussed in the Kingdom's written statement, and I will not dwell on them further, except to make the self-evident point that the Israelis' actions have clearly aimed at frustrating a negotiated settlement rather than opening the door to such settlement. These policies and the practices should be enough to dismantle the illusion that Israel has any intention of engaging in serious efforts towards a negotiated peace. But Israel has also, for good measure, approached actual negotiations with nothing less than impunity and contempt. Mr. President, members of the court, we see this not as spectators, but as a direct participant in efforts towards negotiating a lasting peace spanning decades. That was the case when more than 20 years ago, the Kingdom of Saudi Arabia proposed the Arab Peace Initiatives, which was adopted by the Arab League in 2002 and re-endorsed at the 2007 and 2017 Arab League summits. However, this peace initiative was rejected outright by Israel, with its then Prime Minister describing it as a non-starter, because it required Israel to forego occupied territories in exchange for peace, a policy that has persisted until today. The reality today has become more discouraging. At the senior levels of the Israeli government, calls are openly made to forcibly transfer or ethnically cleanse Palestinians out of their homeland, expand settlements even further, annex further areas of the West Bank, and at all costs to reject the notion of establishing a Palestinian state along the lines of the two-state solutions. And while the brutal and genocidal onslaught of Gaza by the Israeli military since October 2023 has led it to become, in the words of the United Nations Under-Secretary General for Humanitarian Affairs, a place of death and despair. It should not be forgotten that Israel's aggression has been accompanied by unyielding statements by its leaders that it will never agree to a sovereign Palestinian state or cede control over the occupied Palestinian territory. Such a statement hurriedly reflects Israel's intention to engage in a genuine peace negotiations. Concluding at this point, I would add that if a serious negotiations aimed at achieving a just resolution of the Israeli-Palestinian dispute in accordance with the international law were to become reality, the court's opinion could not in any case possibly prejudice those discussions, but rather would enlighten them. Mr. President, member of the court, the second argument raised by certain states is that the court should refrain from rendering the requested opinion because it relates to a strictly bilateral matter between Israel and Palestine. This argument has been rejected by the courts in several prior contexts, including the World Advisory Opinion, and should, we believe, be disposed of by the court in the same manner in this case. Not only is the argument legally unfounded, but the fact that the questions posed to the court are of a multilateral nature is self-evident. As explained in the Kingdom's written statement, the legal questions are located in a broader context, involve erga omnes obligations and jus cogens norms, and ask about the consequences of Israel's policies and practices in all states as well as the United Nations. To conclude on the question of the court jurisdiction, I have with one thought that the Kingdom also voiced in the context of the World Advisory Opinion. If this court, the principal judicial organ of the United Nations, should not consider the critical questions put before it, then we cannot but conclude that the system to maintain international peace and security set up following the atrocities of the Second World War has not stood the test of time. Mr. President, members of the court, I will now address the first questions before the court, which concerns the legal consequences arising from Israel's prolonged occupation and illegal policies and practices in the occupied Palestinian territory. To answer these questions, the court has a plethora of evidence available. This includes the evidence furnished by the United Nations, its organs, UN human rights mandate holders, and the specialized agencies, the special rapporteurs, and the independent commission, all available in the dossier before this court or referred to in the Kingdom's written statement. We submit that the catastrophic consequences of Israel's policies and practices on the ground, as well as their sheer illegality, are undeniable. The international community has seen stark evidence of these consequences during the current war in Gaza. The ongoing situation is so appalling that last December, the UN General Assembly overwhelmingly passed a resolution demanding an immediate humanitarian ceasefire in Gaza, while the court has recognized the plausibility that Israel's conduct amounts to a genocide and ordered it to comply with a series of professional measures. However, as we speak, Israel continues to defy the international community's call for a ceasefire and to willfully ignore the professional measures ordered by the court. More generally, Israel has, over the decades of its occupation, resisted egregious violations of its most fundamental international obligations, as explained in our written statement. Israel in continuous breach of several just cogent norms, notwithstanding multiple Security Council and General Assembly resolutions condemning its conduct and this court's finding in the World Advisory Opinion. These violations include Israel taking continuous measures to prevent the Palestinian people from exercising their right of self-defense through various policies and practices, including, among others, the illegal settlement practice in the occupied Palestinian territory, the expulsion of Palestinians from their homes, and theft of Palestinians' property, the denial of sovereignty over their natural resources, and the breach of their civil, political, economic, social, and cultural rights. Moreover, Israel has continued implementing its infamous settlement practice in the occupied Palestinian territory, despite the repeated condemnation of this practice by the Security Council and this court's determination of their illegality in the World Advisory Opinion. Yet, Israel makes no secret of its intention to maintain and expand settlements, as well as its possession of all or part of the occupied Palestinian territory, in violation of the Fourth Geneva Convention and the prohibition and the acquisition of territory by the use of force. Israel's 2018 Basic Law also shows Israel's disdain for the Palestinian people's right to self-determination by declaring the holy city of Jerusalem complete and united as Israel's capital, stipulating that, quote, the exercise of the right to national self-determination in the state of Israel is unique to the Jewish people, end of the quote. It's also incompatible with the Palestinian people's right to self-determination in the occupied Palestinian territory, including East Jerusalem. The international community has spoken on these issues on many occasions through the United Nations principal bodies, demanding that Israel completely ceases all settlement activities, revoke its annexation of East Jerusalem, and comply with its international obligations in other respects. The list of resolutions is long. We have addressed many of them in our written statements. Israel continues to ignore them. But Israel's breaches of international law don't end there. There can be no serious debate that Israel's policies and practices also amount to the racial discrimination and are tantamount to apartheid in the grave violations of the Palestinian people's human rights. Israel's seizure of land and resources for Israeli settlers and discriminatory application of laws, regulations to the detriment of the Palestinian people are merely examples of this egregious conduct. Israel violates the human rights of the Palestinian people in multiple other ways and in breach of its conventional obligations, including the rights of women and children. Mr. President, members of the court, the Kingdom of Saudi Arabia wishes to emphasize that the international law obligations, particularly those embodied in the preemptory norms of general international law, are not abstract rules and are not intended to be. Their violations entail particular legal consequences, but also has real and tangible consequences. The latter include, most prominently, the denial to human beings of the right to life and dignity, and more widely, the creation of threats to peace and stability, with unpredictable consequences. The multiple and grave violations by Israel of its international obligations in the occupied Palestinian territory is therefore of undeniable concern, not only to those directly affected, but also to the international community as a whole. I will now move on the second question before the court regarding the manner by which Israel's conduct affects the legal status of its occupation. The Kingdom respectively submits that the only conclusion which may be reached from the multiple and grave breaches of international law emanating from its occupation is that Israel's occupation itself is illegal and must be brought to an unconditional end. Any other conclusion would be anomalous and inconsistent with the clearly illegal origin and conduct of the occupation, including the violations of just Cogan's norms that Israel has and continues to engage in through its occupation. To be clear, Israel's occupation was, from its commencement in 1967, an illegal use of force and continues to be so. The Kingdom noted this in its submission in the Wall Advisory Opinion. The illegal nature of the 56-year occupation has only been aggravated by Israel's numerous other international violations, including just Cogan's norms. Given the illegality surrounding every aspect of Israel's occupation, that occupation is simply indefensible as a matter of international law. For those reasons, we respectively ask the court to expressly declare that Israel's occupation of the Palestinian territory is illegal. The court is also asked to address the legal consequences of Israel's breaches. I will address these briefly. The Kingdom of Saudi Arabia and numerous other states have laid out in the written statement the legal obligations which flow from Israel's breaches. Pursuant to Article 30 of the Articles on State Responsibility, and as explained by this court in the Wall Advisory Opinion, Israel must cease its wrongful conduct, resume compliance with its obligations, and offer appropriate assurances and guarantees of non-repetition. Article 31 and 36 also require that Israel makes full reparation for the damage caused over the decades of its illegal occupation. As for all other states, Israel breaches of just Cogan's norms entails that the international community has an obligation not to recognize that illegal conduct. All states must also cooperate to bring Israel's violation of international law to an end and make sure that they don't render aid or assistance in furtherance of Israel's breaches. The consequences for the United Nations are clear. All UN organs must, within their competences, take steps to bring Israel's violations to an end, and they must also refrain from recognizing these violations or giving aid or assistance to maintain the illegal situation. Finally, they must also require the unconditional and immediate end to the occupation itself. Mr. President, members of the court, thank you for your attention. This concludes the statement of the Kingdom of Saudi Arabia.
Its presentation, I invite Before I invite the next delegation to make its oral statement, the court will observe a coffee break for 10 minutes. The sitting is suspended.
Rejuvenating media day by day. This is Salam Media. After the recent attacks on Gaza, many families have been displaced with their homes left destroyed. Through your donations, our teams are on the ground in Gaza, providing support and delivering necessary aid to families affected. The people of Gaza need your help. Give hope. Donate today to Penny Appeal South Africa. www.pennyappeal.org.za 031 1100 573.
Are here on the ground with many appeal organizations in Gaza.
Shimmer, sparkle, captivate. Nothing less than a masterpiece. Droplets of gold inspires precious design. Platinum bursts with intricate freshness, and every pure diamond becomes more than just a girl's best friend. Voda Gold Gem Jewelers, where timeless dreams become a reality. Come to us. We tailor-make designer gold, platinum, and diamond jewelry. Trade in or remodel your old gold. Clad yourself with classy name-branded watches. We offer insurance valuation and freezer card calculation. Visit us at 534 Ridge Road, Overport, or call 031 208 9142. Voda Gold Gem Jewelers, manufacturers of fine gold and diamond jewelry.
World-class financial services only at Sapphire Global, your financial partner. If you are looking for Islamic, Sharia, and ethical financial products, look no further. Sapphire Global offers a wide range of financial service offerings from short-term to life and investments. A full-service center with all financial requirements under one brand. Our highly skilled and experienced consultants are ready to help protect your financial future. Contact us on 041 001 0184 or visit our website on www.sapphireglobalfs.com. Sapphire Global is an authorized financial services provider.
You know, it's a wonder how kids get anything done these days. With all the distractions, when do they even get time to study? As a mother, all I can really do is make sure they have all they need to perform at their best. That's why I choose to include Sunfoil, triple refined pure sunflower oil with every meal I make. Naturally cholesterol-free and approved by the Heart and Stroke Foundation as part of a balanced eating plan. So whether I'm cooking, frying, or baking, I know every dish will be a wholesome one. Sunfoil, now we're cooking.
Sponsor an orphan, and you'll help support a vulnerable child to have the education they've always dreamed of, so they can build a brighter future. You'll be feeding a hungry stomach and a hungry mind with knowledge that will last them a lifetime. That's the power of an education. Sponsor an orphan now with Islamic Relief.
When the perfect blend of stylish decor, exquisite halal cuisine, and warm hospitality come together, it could only mean Al Bayt Lodge, your true home away from home. Al Bayt is the ideal heaven for families, business people, and tourists with its 4-star family rooms and other luxurious facilities, conveniently situated close to Port Elizabeth Airport, the beach, and other amenities. Your stay will be truly unforgettable, as you'll be taking home lasting memories of the warm hospitality, the serenity and tranquility that Al Bayt has to offer. For reservations, call 041 583 6415 or visit www.albaytlodge.co.za.
The road to salvation is filled with temptation. Trials and tribulations grant us motivation to seek out elevation so our nation doesn't fail. But Allah will not change our situation until we change ourselves. Only He can turn the impossible into possible. When life is full of obstacles and patience is optional, remember who's responsible in this journey we call life, for guiding all us sinners from darkness into light.
The walls begin to set in. But I'm not afraid, 'cause the darkness knows my name. Have I fallen too far, far beneath? Most days I feel like I'm not even here. Ain't no one waiting for me. Don't come around, oh, there's nothing to see. Lost all my love, wasted my tears. I've no more to lose, so I've nothing to fear. I'm tearing it down, this hollow ground. There's no need for goodbye. Oh, this world is so cruel. So goodbye, gentle soul. I ain't coming back home like I was before. 'Cause this rabbit hole, there's no wonders it holds, only hell below. Respect I gain, a fearful name. All mine, 99 lives I claim. Doesn't build me up, doesn't go away. All those eyes, they watch me night and day. Is there a heaven still waiting for me? Can redemption come before my final sleep? Or am I too far gone? Have I fallen too deep? Oh no, holy man, don't tell me God can't forgive a man like me. I've become so cruel. I thought I gained but lost. There's no coming back home. He says you get what you got, but to save his soul, oh, there's gotta be hope from the hell below. 100 now, and all around, their sentence stands, guilty hammers down. But an ember burns, I feel it deep inside. Oh, learned man, tell me where salvation lies. You gotta live right now, leave this all behind. This place won't release you, they only see your crimes. But all our hope's not lost when we have our faith. For Allah's mercy always overcomes his wrath, so you can be saved. I was on my way, not even half but nowhere. The angels came to take my soul away. Oh, the push and pull, the weight of all my sins, and the balance against my will to try again. But then God says, measure the space two ways closest to. Is it the hell he was running from, or the place that was new? But God makes the earth move so he can rescue you. For even if our sins was like water in the ocean, Allah is most merciful. So my story is told for all lost souls. I have come back home despite who I was. I never imagined, and now I behold an ending so beautiful. The light descends and never ends, and I'm not afraid, for Allah knows my name.
If you dare to believe, you will perceive the world differently. Just one heart, one voice, one hand, one smile, one world. From ripples to waves, from whispers to echoes, love sets us free.
Her eyes fade just like her yesterday. She looks at me and says, help me to find my way. See, I've lost everything. Help me to start again. And as I turn away from her, I can still hear her say, is there anyone out there who hears me cry? Anyone beyond the shadows? There's nothing I can give you but my prayer. Don't you see love sets us free? If you dare to believe, one heart can heal another, one hand can lift us higher. If you dare to believe, one voice brings hope, with one smile we save each other. If you dare.
Since the world's gone to ashes, dark and gray, if we all shine the light, it will light up a way. Then we see beyond the color, beyond nations and tribes. We're meant to learn about each other. Let love be the guide. If you dare to believe, one heart can heal another, one hand can lift us higher. If you dare to believe, one voice brings hope, with one smile we save each other. If you dare to believe, one heart can heal another, one hand can lift us higher. If you dare to believe, one voice brings hope, with one smile we save each other. If you dare. If you dare to believe, one heart can heal another, one head can lift us higher. If you dare to believe, one voice brings hope, with one smile we save each other. If you dare. Welcome, O Ramadan. You are honored, O month of the Quran. It is Ramadan. O one who sleeps, stand up and declare the oneness of Allah, the oneness of Allah. O one who fasts, stand up in prayer at night, and Allah will forgive.
Rejuvenating media day by day. This is Salam Media.
Please be seated. The sitting is resumed. I now call upon the delegation of the Netherlands to address the court and invite Mr. René Lefebvre to take the floor.
Thank you, Mr. President. Mr. President, distinguished members of the court, it is an honor to appear before you today on behalf of the Kingdom of the Netherlands to participate in this hearing on the request for an advisory opinion on the legal consequences arising from the policies and practices of Israel in the Occupied Palestinian Territory, including East Jerusalem. Let me express my sincere appreciation for this opportunity to speak early in this hearing, as the other participants have not had an opportunity to comment on our views in writing. The Kingdom would like to begin by underlining that, for the purposes of the present advisory proceedings, it leaves it to the discretion of the court to satisfy itself that it has advisory jurisdiction and that it may exercise this jurisdiction with respect to the present request, in accordance with Article 65, Paragraph 1 of the Statute of the Court and Article 102 of the Rules of Court. The Kingdom would like to emphasize that it considers that, and I quote from the advisory opinion on the construction of a wall, the object of the request before the court is to obtain from the court an opinion which the General Assembly deems of assistance to it for the proper exercise of its functions, unquote. Therefore, the request should be regarded in a much broader frame of reference than a bilateral dispute. And it is with such broader frame of reference in mind that the Kingdom seeks to assist the court in answering the questions contained in the request through the identification of the applicable international law and the presentation of the legal opinion of the Kingdom on the status and interpretation of that law. Mr. President, distinguished members of the court, the Kingdom would now like to turn to the questions posed in the present request for an advisory opinion. Mr. President, according to the Kingdom, the right of self-determination of peoples is a permanent, continuing, universal, and inalienable right with a peremptory character. The principle of self-determination of peoples is enshrined in Articles 1 and 55 of the United Nations Charter. It is also contained in several resolutions of the General Assembly with historical importance, such as Resolution 1514, which states that, and I quote, "All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue the economic, social, and cultural development," unquote. The right of self-determination has been reaffirmed by the General Assembly in Resolution 2625, pursuant to which every state has the duty to refrain from any forcible action which deprives peoples referred to in that resolution of their right to self-determination. In addition, this right is enshrined in Article 1, common to the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. The Court has acknowledged self-determination as a right of peoples in the Namibia Advisory Opinion, the Western Sahara Advisory Opinion, the East Timor case, the Advisory Opinion on the construction of a wall, and the Advisory Opinion on the separation of the Chagos Archipelago. In the East Timor case, the Court observed that the right of peoples to self-determination is a right erga omnes. The status of the right of self-determination as a right under customary international law is thus beyond reproach. According to the Kingdom, the right of self-determination is applicable in the colonial and in the post-colonial context. The right is, however, equally applicable to peoples under foreign or alien occupation, as confirmed by the General Assembly on several occasions, such as in Resolution 51/84 and its Millennium Declaration. It appears that the right of self-determination is a truly universal and continuing right. It applies to peoples under colonial domination, peoples residing in occupied territory, and peoples living in independent states. As a result, a state that occupies territory is under an obligation to respect and promote the right of self-determination of peoples residing in that territory. The obligation to respect and promote the right of self-determination means that, on the one hand, the occupying state shall refrain from measures that impede the exercise of the right of self-determination of the people concerned during the occupation, and, on the other hand, that the occupying state shall take measures aimed at creating the conditions under which the people concerned is able to freely and genuinely express its will in regard of its future political status. As the Kingdom has observed earlier, under international law, a distinction must be made between situations in which the right of self-determination is exercised in a manner that preserves international boundaries, which can be referred to as internal self-determination, or in a manner that involves a change of international boundaries, often referred to as external self-determination. In the context of colonial domination or foreign occupation, the right of self-determination can be realized through independence, association, or integration. A prolonged occupation obstructs the implementation of the right of external self-determination of a people residing in the occupied territory concerned. In regard of, amongst others, peoples under foreign or alien occupation, the General Assembly reaffirmed in Resolution 45/130, and I quote, "The legitimacy of the struggle of peoples for independence, territorial integrity, national unity, and liberation from colonial domination, apartheid, and foreign occupation by all available means, including armed struggle." Unquote. If a struggle by a people for the implementation of its right of self-determination in the context of colonial domination or foreign occupation is accompanied by the use of armed force by such people, this use of armed force must be in accordance with international law. Mr. President, I will now address the law regulating the use of force, in particular the UN Charter and its prohibition on the use of force by states contained in Article 2, Paragraph 4. According to the Kingdom, the prohibition of the use of force is a rule of jus cogens that applies erga omnes. Indeed, in the advisory opinion on the construction of a wall, the court confirmed that the principles as to the use of force incorporated in the UN Charter reflect customary international law. In 1966, the International Law Commission noted that the law of the UN Charter concerning the prohibition of the use of force in itself constitutes a conspicuous example of a rule of international law having the character of jus cogens. Consequently, the International Law Commission included the prohibition of aggression in its list of rules of jus cogens. One of the established exceptions to the prohibition on the use of armed force is that of the inherent right of individual or collective self-defense, if an armed attack occurs against the state, as codified in Article 51 of the UN Charter. The occupation of foreign territory can be legitimate in the exercise of the right of self-defense in response to an armed attack, provided that the use of force is exercised in accordance with the conditions attached to this right. The substantive customary conditions are necessity and proportionality, in addition to the procedural condition contained in Article 51 to notify the Security Council of the actions taken in self-defense. In the advisory opinion on the legality of the threat or use of nuclear weapons, the court noted, inter alia, that proportionality and necessity are inherent in the very concept of self-defense. So if the placement of a territory under the control of an armed force is the result of a military operation in the exercise of the right of self-defense, necessity requires an assessment of whether the occupation and the continuation thereof is necessary to repel the armed attack or that alternative courses of action are available. This inherently supposes also a temporal element of immediacy. If the right of self-defense is not exercised relatively promptly, it may imply that the exercise of the right of self-defense was unnecessary. Furthermore, with regard to proportionality, the question is whether the occupation and the continuation thereof is proportionate in relation to the armed attack, both in qualitative and quantitative terms. If that is not the case, the occupation may be considered to violate the prohibition of the use of force. These conditions to the exercise of the right of self-defense apply as long as there is an occurring or imminent armed attack. Also, in exercising the right of self-defense, the occupying state must fully respect international law, in particular human rights and international humanitarian law. Mr. President, it is the view of the Kingdom that the right of self-defense can also be invoked in response to an armed attack by a non-state actor. This is illustrated, for example, by the Security Council's resolutions adopted after 9/11, in which the Security Council reconfirmed the right to self-defense in response to those attacks. An occupation which fulfills the requirements of the right of self-defense may be considered as lawful under jus ad bellum. An occupation which does not fulfill or no longer fulfills these requirements may lose its legal basis and hence violate the jus cogens prohibition of the use of force. Finally, the Kingdom underscores that occupation is an inherently temporary use of force, because if it were to be permanent, it would qualify as annexation. As the Security Council emphasized in 1967, in its unanimously adopted Resolution 242, the acquisition of territory by war is inadmissible. The Court recognized the customary status of the illegality of territorial acquisition resulting from the threat or use of force in the advisory opinion on the construction of a wall. Mr. President, the Kingdom now turns to international humanitarian law, or jus in bello, which regulates situations of armed conflict, including occupation. According to the court, and I quote, "A great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations of humanity," end of quote, "that they are," and I quote, "to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law," end quote. In the court's view, these rules incorporate obligations which are essentially of an erga omnes character. The Kingdom considers these principles, furthermore, to be a peremptory norm of general international law, and would like to refer in this respect to the conclusion of the International Law Commission to include the basic rules of international humanitarian law in its list of rules of jus cogens. The Kingdom submits that while international humanitarian law is applicable in situations of occupation, international humanitarian law does not contain rules for determining whether an occupation is lawful or unlawful as such, even if breaches of the rules are serious in nature. Rather, irrespective of its legality, international humanitarian law regulates situations of occupation once such a situation has arisen in fact. As noted by the court, and I quote, "Under customary international law, territory is considered occupied when it is actually placed under the authority of the hostile army, and the occupation extends only to the territory where such authority has been established and can be exercised," unquote, as reflected in Article 42 of the Hague Regulations of 1907. As stated before, inherent in occupation is its temporary nature. Under the Hague Regulations, the occupying power shall be regarded only as administrator or usufructuary. After the Second World War, the Fourth Geneva Convention further developed the law of occupation by significantly enhancing the protection of civilians in situations of occupation. As noted by the court, the intention of the drafters of the Fourth Geneva Convention was to protect civilians who find themselves, in whatever way, in the hands of the occupying power. Furthermore, the drafters of the Fourth Geneva Convention sought to guarantee the protection of civilians in time of war, regardless of the status of the occupied territories. Once an occupation has factually occurred, the occupying power is obliged to act in accordance with the law of occupation. The occupying power has to respect and protect the civilians in the occupied territory who are regarded as protected persons. Protected persons are, inter alia, entitled in all circumstances to respect for their persons and shall at all times be treated humanely. Private property is to be respected. At the same time, such measures of control and security may be taken by the occupying power in regard to protected persons as may be necessary as a result of the war. As noted before, no sovereignty can be established over occupied territory, and occupied territory may not be annexed. In this regard, an important provision under the law of occupation is that the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Under international criminal law, such transfers, directly or indirectly, by the occupying power, constitute a war crime, as reflected in the Rome Statute of the International Criminal Court. It is also prohibited to deport protected persons from the occupied territory. The Kingdom underscores that all high contracting parties to the Geneva Conventions are under an obligation to ensure respect for the Geneva Conventions, with reference to Article 1, common to those conventions. As noted by the court, and I quote, Every state party to that convention, whether or not it is a party to a specific conflict, is under an obligation to ensure that the requirements of the instruments in question are complied with, unquote. Mr. President, in relation to international human rights law, the Kingdom would first note that this body of law continues to be applicable during situations of armed conflict, including occupation. The Court has come to this conclusion in its advisory opinions on legality of the threat or use of nuclear weapons and construction of a wall. It added, in the case concerning armed activities on the territory of the Congo, that, and I quote, international human rights instruments are applicable in respect of acts done by a state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories, end of quote. The International Law Commission has equally concluded that human rights treaties continue to apply during armed conflict in its 2011 draft articles on the effects of armed conflicts on treaties. It follows that an occupying power, for the purposes of international humanitarian law, is bound to respect, protect, and fulfill the human rights of all those within the occupied territory. The obligations owed by states under rules of universally applicable customary international human rights law are of an erga omnes character. The Court has confirmed this in the Barcelona traction case, considering that erga omnes obligations, and I quote, derive, for example, in contemporary international law from the principles and rules concerning the basic rights of the human person, unquote. According to the Court, this includes the prohibitions of genocide, slavery, and racial discrimination, as well as the prohibition of torture. Certain rules of international human rights law can moreover be characterized as peremptory norms of international law. According to the International Law Commission, this includes the prohibition of genocide, the prohibition of torture, the prohibition of slavery, and the prohibition of racial discrimination and apartheid, as well as the right of self-determination. Mr. President, both questions before the Court concern the legal consequences of ongoing violations of rules of international law. Several of these rules are, as indicated, peremptory norms of general international law. As we have stated before, all such peremptory norms are applicable erga omnes. I will now address the additional legal consequences for all states and international organizations in the event of a serious breach of such a peremptory norm. It being noted that these consequences are additional to the regular obligations arising from the commission of an internationally wrongful act. The rules on the legal consequences for states when a serious breach of a peremptory norm occurs are reflected in Articles 40, 41, and 48 of the Articles on the Responsibility of States for Internationally Wrongful Acts. The relevant provisions for states and international organizations may be found in Articles 41, 42, and 49 of the draft Articles on the Responsibility of International Organizations. According to the Kingdom, these provisions reflect customary international law. These legal consequences may be divided in two categories: substantive consequences and procedural consequences. I will only address the Articles on State Responsibility in my statement. However, it is equally applicable to the draft Articles on the Responsibility of International Organizations. Article 40 of the Articles on State Responsibility defines a serious breach as a gross or systematic failure by the responsible state to fulfill its obligation under a peremptory norm. Article 41 stipulates the particular substantive consequences of such a breach, not only for the responsible state, but for the international community as a whole, including that state. In sum, states shall cooperate to bring the serious breach to an end. shall not recognize as lawful a situation created by such breach and shall not render aid or assistance in maintaining the situation. The court has confirmed the binding nature of the rules reflected in Article 41 in jurisdictional immunities. The court has on multiple occasions pronounced on the legal consequences of serious breaches of norms affecting the international community as a whole. In Barcelona Traction, the court established that obligations owed towards the international community as a whole are the concern of all states, and that, and I quote, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. They are obligations erga omnes, end of quote. The court further confirmed these obligations in its advisory opinions on Namibia, the construction of a wall, and the separation of the Chagos archipelago. Thus, the jurisprudence of the court supports the obligations reflected in Article 41 of the Articles on State Responsibility. The court has also identified the obligation of non-recognition and the prohibition to render aid and assistance, and the obligation to cooperate to bring the consequences of the serious breach of a peremptory norm to an end. As to the specific implementation of these rules, the Kingdom observes the following. First, the obligation to cooperate to bring to an end the consequences of the serious breach of a peremptory norm will, in most cases, and particularly in cases concerning self-determination and decolonization, be implemented most effectively through the United Nations. However, should cooperation in the context of the United Nations fail to materialize, or should the United Nations be unable to take appropriate action, states are not relieved from their obligation to cooperate to bring the consequences of the breach to an end. In that case, they are obliged to seek cooperation through regional or bilateral fora. Second, the obligation not to recognize as lawful the situation brought about through the serious breach of a peremptory norm must take into account the exceptions to that rule as formulated by the court in the Namibia advisory opinion. Third, the rendering of unlawful aid and assistance contrary to the prohibition thereto does not give rise to international responsibility of the aiding or assisting state for the underlying situation or internationally wrongful act, but only for its unlawful aid or assistance. Fourth, the obligation not to render aid or assistance includes an obligation not to undermine measures, including sanctions, taken by other states in their endeavor to bring to an end the serious breach of a peremptory norm. In particular, when the state undermining those measures does so knowing that its conduct contributes to the maintenance of the unlawful situation. Finally, it is our view that a serious breach of a peremptory norm entitles states, other than the injured state, to take a countermeasure against the responsible state as a legal consequence of that breach. Such resort to countermeasures by a non-injured state must be in accordance with the customary rules on countermeasures, including the conditions of proportionality and reversibility. As a final observation, it may be recalled that the Kingdom considers that all peremptory norms are applicable erga omnes. Therefore, the procedural legal consequence of a serious breach thereof is that all states and international organizations have legal standing to invoke responsibility for such a breach. They may claim cessation of continuing internationally wrongful acts, assurances and guarantees of non-repetition, and performance of the obligation of reparation. A claim concerning reparation is restricted in the sense that it must be in the interest of the injured state or international organization or of the beneficiaries of the obligation breached. And such beneficiaries may include individuals and peoples. Mr. President, this brings me to the end of my statement. We sincerely hope that your advice will contribute to achieving peace in the Middle East. Thank you, Mr. President.
I thank the delegation of the Netherlands for its presentation. I invite the next participating delegation, Bangladesh, to address the court. Let me call upon His Excellency, Mr. Riyaz Hamidullah, to take the floor.
Mr. President, members of the court, it's my distinct honor and privilege to address the principal judicial organ of the United Nations on behalf of the People's Republic of Bangladesh and participate in these advisory proceedings on the legal consequences arising from the policies and practice of Israel in the occupied Palestinian territory, including East Jerusalem. Bangladesh fought for 23 long years to gain her independence and finally achieved it through a bloody war in 1971, during which 3 million people had to sacrifice their lives. In the early days of independent Bangladesh, in 1972, our father of the nation, Bangabandhu Sheikh Mujibur Rahman, said, I quote, "The world is divided in two parts, oppressors and oppressed, and I am with the oppressed," unquote. As Bangladesh pursued her own self-determination, our constitution mandated us to support oppressed peoples worldwide who are fighting imperialism, colonialism, or racism. This duty is outlined in Article 25C of our constitution. In accordance with this duty, Bangladesh is participating in these advisory proceedings to contribute to the realization of the right of the Palestinian people to self-determination. We aim to achieve this by providing this court with our perspectives on the questions asked by the UN General Assembly in the current request for an advisory opinion. Bangladesh has long reiterated the call to end Israel's occupation of Palestine and to achieve a lasting and permanent solution, which entails the establishment of a sovereign and independent Palestinian state along the pre-1967 borders, with East Jerusalem as its capital. We firmly believe that the court must heed the long overdue call to holistically examine Israel's occupation and render an opinion on the legal status of the occupation as a whole. As we heard in this very hall just last month, Gaza has been described as a living hell. On 20th May 2021, even before the ongoing war, Mr. Antonio Guterres, the UN Secretary General, said, I quote, "If there's a hell on earth, it is the lives of children in Gaza," unquote. I stand before the court also in the context of the fast developing circumstances in Rafah, with grave humanitarian implications for the 1.4 million Palestinian people, nearly half of them children. The ongoing war represents one of the most shameful catastrophes in the history of the modern era. The UN agencies and other humanitarian aid organizations on the ground have warned of a humanitarian disaster engulfing the tiny enclave of 2.3 million people with shortages of food, fuel, drinking water, and medicines worsening by the day. The killing of thousands of innocent civilians, particularly children, the destruction of their homes, the occupation of their ancestral lands, and the deliberate obstruction of the access to food and water all constitute blatant violations of international law and serve as textbook examples of ethnic cleansing. Bangladesh firmly believes that an advisory opinion on the questions posed by the General Assembly would undoubtedly represent a critical and logical step towards ending the illegal occupation. The dismantling of this occupation would, in turn, address the root cause of Israel's violent subjugation of the Palestinian people. We elaborated on these matters and the underlying reasoning in our submissions before the court, Mr. President, on 24th July and 25th October last year. It is pertinent to recall that just 4 months back, the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territories, Francesca Albanese, in her report, brought up several appalling facts. I would consider it apt to quote one pertinent aspect, and I would quote, "In the occupied Palestinian territory, the fundamental right to life is under threat, as indicated by the mortality rates of Palestinian children. The neonatal mortality and infant mortality rates in the occupied Palestinian territory are respective 9.3 and 12.7 per 1,000 live births, rising to 14.8 per 1,000 live births for children under 5, while in Israel, they are 1.7, 2.7, and 3.4 per 1,000 live births. In addition to direct attacks on the right to life, Palestinians also endure structural violence and racial discrimination, which impedes their full development, unquote. These structural violence of the occupation and the deliberate and excessive use of force against the Palestinians are indeed not limited to the recent events in Gaza. As the special rapporteur, Ms. Albanese, stated in her 2023 report, I quote, "The specter of death looms as a dominant element in the lives of Palestinian children. This reality exerts a psychosocial toll on those who manage to survive, as pointedly expressed by Oadia, a 14-year-old girl. I quote, as she said, "Fearing death does not prevent you from dying, but it prevents you from living," unquote. Thousands of Oadias keep crying in silence, deprived and disenfranchised for decades. Ending the occupation would necessarily bring an end to the violence that is exercised upon Palestinians on a daily basis. However, there is no end to the occupation in sight, nor is it likely to end through political means alone. It has become interminable. That much was all but confirmed by Israel's Prime Minister, Mr. Benjamin Netanyahu, on 18 January 2024. The court's intervention to us is therefore both timely and necessary. As I proceed with this oral statement, I wish to address whether the occupation of Palestinian territory by Israel is illegal or not. Even though the great majority of states participating in these proceedings, including Bangladesh, are firmly convinced that the occupation is illegal, we note that 2 states contend that it is not. Next, I'll state the legal consequences that, in our view, derive from the illegal status of the occupation. On Israel's illegal occupation, Mr. President, members of the court, the fundamental question posed by the UN General Assembly regarding the legality of the Israeli occupation is grounded in established international norms and legal principles. The State of Palestine, in its written statement, underscores the colonial and acquisitive nature of the occupation, emphasizing its deleterious impact on the Palestinian people. The occupation, characterized by persecution, racial discrimination, and apartheid, stands in clear violation of 3 preemptory norms of international law: the right to self-determination, the prohibition of acquiring territory by force, and the prohibition of racial discrimination and apartheid. Numerous submissions have echoed these sentiments, highlighting the temporary nature of belligerent occupation as mandated by international law. The annexation of occupied territory and the settlement of the occupying power's nationals in the occupied area are explicitly prohibited, constituting illegal acquisition of territory under the UN Charter and relevant UN resolutions. Israel's prolonged occupation, coupled with its policies of colonization and annexation, underscores its illegality under international law. These actions not only contravene the UN Charter, but also violate general international law, including the preemptory norm prohibiting the acquisition of territory by force. Furthermore, arguments put forth by states and international organizations reject any justification for Israel's occupation on grounds of self-defense. The occupation violates fundamental principles of international law, including the right to self-determination and the prohibition of acquiring territory by force. The advisory opinion on Wall, which concluded that Israel cannot rely on self-defense to justify its actions, reinforces the notion that the occupation cannot be justified under international law. While the countries supporting Israel in these advisory proceedings have primarily focused on jurisdictional questions, a few states have addressed the merits of the occupation. One contends that an occupation can never be unlawful, regardless of violations of international humanitarian law. However, this argument stands in contravention of established legal principles and has been widely found to be incorrect. Switzerland's distinction between the law of occupation and the legality of occupation further elucidates the legal framework surrounding the issue. An occupation that involves annexation or de facto control of the occupied territory constitutes an illegal acquisition of territory by force as prohibited under international law. Ultimately, Israel's occupation, characterized by its acquisitive, colonial, and annexationist nature, represents a clear violation of international law. It serves as a means for the illegal acquisition of territory and must be brought to an immediate and unconditional end. I may also recall the UN Security Council Resolution 2334 of 23rd December 2016, which reaffirmed the obligations of Israel, the occupying power, to abide scrupulously by its legal obligations and responsibilities under the 4th Geneva Convention in regard to the protection of civilian persons in time of war. That Security Council resolution also condemned all measures aimed at altering the demographic composition, character, and status of the Palestinian territory occupied since 1967, including East Jerusalem, including, inter alia, the construction and expansion of settlements, transfer of Israeli settlers, confiscation of land, demolition of homes, and displacement of Palestinian civilians in violation of international humanitarian law and relevant resolutions. Israel has flagrantly violated this and all other Security Council resolutions, and it continues to do so in furtherance of permanently maintaining its illegal occupation of Palestinian territory. At a more granular level, may I refer to the approaches of assessing legality advanced by the former UN Special Rapporteur, Michael Link, in his 2017 report to the UN General Assembly, and the current Special Rapporteur, Francisca Albanese, in her 2022 report. These are apposite and relevant to the court's task in this case. The two approaches overlap and interrelate, but ultimately provide two pathways for determining the legal status of the occupation. I may humbly request the court to consider the Link report, where he proposed a 4-part test for determining the legality or illegality of an occupation. The Special Rapporteur's approach also fits within the parameters of the court's advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia. That opinion arose out of Security Council resolution declaring South Africa's continued presence in Namibia illegal. If South Africa's mandate could be found to be illegal due to its violation of the applicable international legal principles, so too can Israel's occupation by reason of its violation of the same principles. Therefore, applying one or both of these frameworks, which Bangladesh endorsed for the reasons stated in our written submissions, we'd respectfully submit that Israel's occupation is undoubtedly illegal. I would now turn on the legal consequences. Mr. President and members of the court, there's a broad consensus that Israel, through its denial of the Palestinian people's right to self-determination, has violated preemptory norms of international law. These violations include persecution, racial discrimination, and apartheid against Palestinians, as well as the occupation, colonization, and annexation of Palestinian land. These systematic breaches severely undermine the rights of Palestinians as a people and Palestine as a state, while also hindering the prospects for a just and lasting peace in accordance with international law and relevant UN resolutions. Consequently, international law mandates the complete, unconditional, and immediate cessation of these internationally wrongful acts. All states and international organizations that have condemned Israel's conduct agree that these systematic and grave breaches carry legal consequences for Israel. As the responsible state, other states, and the United Nations and other intergovernmental organizations. So, on legal consequences for Israel, first, Israel must cease all acts preventing the exercise of the right to self-determination by the Palestinian people, including rescinding discriminatory laws and measures. This cessation includes withdrawing occupation forces, dismantling illegal structures such as settlements and the wall, and repealing annexation-related legislation. And secondly, Israel must provide reparations for the damages caused and guarantee non-repetition. On the legal consequences of all other states, first, all states must ensure the immediate cessation of any impediment to the exercise of the Palestinian people's right to self-determination and uphold the prohibition of acquiring territory by force and racial discrimination and apartheid. And secondly, states must not recognize the illegal situation resulting from Israel's wrongful acts, including in Jerusalem, and must not provide aid or assistance to maintain this situation. Cooperation is essential to ensure Israel's compliance with international law and humanitarian standards. On legal consequences for the United Nations, first, the UN General Assembly and the Security Council should consider further action to immediately end the Israeli occupation and remove obstacles to Palestinians' rights, including self-determination. And secondly, immediate action is necessary to end the system of apartheid set up by Israel, with relevant UN resolutions implemented without delay. Mr. President, distinguished members of the court, the promise of a Palestinian state based on a diplomatic settlement grounded in law has been a prominent feature of the international agenda since 1948. 75 years later, there exists a vast body of practice, state practice, and opinion jurists that emphatically support the Palestinian people's right to an independent state. The UN Security Council and the General Assembly have adopted numerous resolutions since 1948 on the question of Palestine, recognizing, among other rights, the right of return for Palestinian refugees and the right of Palestinians to establish an independent state along the pre-1967 borders. Additionally, both the UN General Assembly and the Human Rights Council have acknowledged the Palestinian people's right to self-determination. Importantly, in 2004, this court, in its advisory opinion on the wall, explicitly affirmed the Palestinian people's right to self-determination under international law. Bangladesh, drawing on our agonizing struggle for independence, recognizes how the state of Palestine consistently and conclusively reaffirmed her commitment to a peaceful solution. This solution, in accordance with international law and based on the aforementioned terms of reference, aims to ensure the fulfillment of the Palestinian people's inalienable rights under international law. These rights include self-determination, the right of return, the realization of independence and sovereignty of the state along pre-1967 borders, with East Jerusalem as its capital, and the aspiration to live side by side in peace and security with Israel. The court's steadfast commitment to universally uphold rule of law, coupled with its principled stance on the legality of Israel's half-century temporary occupation of the occupied Palestinian territory, would shine a light of hope on the beleaguered Palestinian people. A decisive determination by the court of the illegal status of the Israeli occupation of Palestinian territory and the legal consequences that arise from such status, including an immediate, unconditional, and complete end to the occupation, would help secure the identity, respect, dignity, and existence for the present and future generations of the Palestinian people in a state of their own, at peace with Israel. Mr. President, members of the court, Palestinians are no expandable people. As much as this advisory opinion involves legal questions, it poses an exceptional moral issues for the humanity. I stand before the court as Bangladesh deem it our sacred duty to uphold international law as well. On behalf of Bangladesh, I therefore respectfully request the court to give full consideration to the importance of an advisory opinion at this critical moment. I'd like to thank you, Mr. President, as well as the distinguished members of the court for granting Bangladesh this opportunity to participate. Thank you.
I thank the delegation of Bangladesh for its presentation.
I invite the next delegation, Belgium, to address the court and call to the podium Mr. Piet Herbut. You have the floor, sir.
Mr. President, honourable members of the court, it is a great honour for me to appear before you as agent for the Kingdom of Belgium in these oral proceedings concerning the request for an advisory opinion, which was submitted to you by the United Nations General Assembly in its resolution of the 30th of December 2022. Belgium is grateful to the court for having given it the opportunity to be heard in these advisory proceedings. In light of the time available to it, Belgium shall limit its submissions to the matter of settlement and its legal consequences. As Belgium has already had the opportunity to underline, notably when it addressed the United Nations Security Council, Israel has established a veritable policy of settlement in the occupied Palestinian territory for decades now. This policy is carried out by means of a series of associated measures, which are indissociable from establishment of the settlements themselves. Now, with your leave, I will first set out the general relevant legal framework, relevant when it comes to the matter of settlement of the occupied Palestinian territory. I will then spend a moment on the unlawful nature of the establishment of the colonies. Professor Vaius Koutroudis will then look at the relevant rules with respect to the unlawfulness of the policy of settling the occupied Palestinian territory and the related measures adopted by Israel in that connection. And he will conclude by setting out briefly the legal consequences of the violations of international law that we shall identify or that have been identified. Mr. President, Belgium will start its statement by a brief recall of the relevant legal framework relevant to the issue of settlement. Now, Israel's policy of settlement is being implemented in the general context of the prolonged occupation of the Palestinian territory. Now, in its advisory opinion of the 9th of July 2004 on the legal consequences of the construction of a wall in the occupied Palestinian territory, the court provided the following clarifications regarding the general legal framework regarding the occupation in question. Firstly, the Palestinian territory had been controlled by Israel since 1967, including eastern Jerusalem, and that this territory was an occupied territory. Secondly, the illegality of territorial acquisition by force of the occupied Palestinian territory was established. And this rule prohibits the annexation of territory by Israel, including annexation of a de facto nature. Thirdly, Article 51 of the UN Charter was found by the court to have no relevance in this case because the territory in question was a territory occupied by Israel. Fourthly, the Palestinian people enjoyed a right to self-determination. Fifthly, the instruments relative to the protection of human rights applied in an extraterritorial fashion, including in the situation of an armed conflict and military occupation. So from what I have just said, it is clear that all territory effectively controlled by Israel beyond the 1967 borders is an occupied territory, and that its annexation in whole or in part, be it de jure or de facto, was prohibited under international law. And therefore, the following apply to the occupied Palestinian territory. First of all, the rules of treaty-based or customary nature of international humanitarian law, in particular those which are set out in the settlement annexed to the Fourth Convention of The Hague of 1907, as well as all of the rules of the Fourth Geneva Convention of 1949. Also, the following apply: the right to self-determination and rights relative to the protection of human rights. In the case of prolonged occupation, human rights are of a particular importance when it comes to protecting the occupied population. In this connection, it should be noted that the term prolonged occupation does not relate to a specific legal category to which different rules apply. In other words, the same rules apply to all occupations, be they prolonged or not. The prolonged nature of an application does not have an effect on the applicability of the rules, but rather on their application. And so it is, for example, that the longer an occupation persists, the more difficult it becomes to invoke exceptions related to the military necessities of the occupying power, which are such exceptions being provided by certain rules of international humanitarian law. It is also ever the more difficult to invoke derogations related to the requirements of those instruments which protect human rights. Similarly, the longer the occupation, the more broadly the obligations, the positive obligations of the occupying power must be interpreted. These obligations are obligations regarding conduct. The states must deploy all means reasonably available to them to fulfill them, and a situation of prolonged occupation, in a situation of prolonged occupation, the control established implies that the occupying power has more means available to it to meet the positive obligations deriving from international humanitarian, international human rights law. Now, having made this or given this brief presentation of the general legal framework, I will now spend some time looking at the unlawful nature of the establishment of these settlements in the occupied Palestinian territory. Paragraph 6 of Article 49 of the Fourth Geneva Convention of 1949 provides that the occupying power, and I quote, "the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies," end of quotation. And in its advisory opinion of 2004, your court found that, and I quote, "Israel has conducted a policy and developed practices involving the establishment of settlements in the occupied Palestinian territory, contrary to the terms of paragraph 6 of Article 49, end of quotation." Now, in line with these findings of the court, Belgium avers the unlawful nature of the establishment of settlements in the occupied Palestinian territory under the Fourth Geneva Convention. Furthermore, Belgium considers that establishment of the settlements was inconsistent with the relevant resolutions of the Security Council. Now, given that I do not have much time, I will simply point you to Resolution 2334 adopted on the 23rd of December 2016. Now, based on the criteria set out by your court in its advisory opinion on Namibia, this resolution is certainly one which sets out the obligations bearing upon members of the United Nations. And so, Having stated that the creation of settlements constituted a flagrant violation under international law, the Security Council, and I quote, reiterated its demand that Israel immediately and completely cease all settlement activities in the occupied Palestinian territory, including East Jerusalem. End of quotation. Now, in light of the clear wording of the paragraph I've just quoted, it is clear that Israel's pursuance of the settlement policy contravenes Resolution 2334 issued by the Security Council. Now, that brings me to the end of the second point in these oral presentations by Belgium. Mr. President, with your leave, I will now offer the floor to Professor Vaius Koutroulous, who will continue the presentation.
I thank Mr. Erbout. I now give the floor to Professor Vaius Koutroulous. You have the floor, sir.
Mr. President, honourable members of the court, it is a great honour for me to appear before you for the first time on behalf of the Kingdom of Belgium. I will now continue on with Belgium's oral submissions by stating the relevant rules which are relevant to the unlawfulness of the settlement policy, the policy of settling the occupied Palestinian territory, and then I will conclude with the legal consequences of the violations identified. Now, in its Resolution 2334 of 2016, the Security Council very clearly emphasizes the multidimensional nature of the policy of settling the occupied Palestinian territory. Along the same lines, Belgium, in its interventions before the Security Council, stressed the relationship between the establishment of settlements and its associated measures which are an integral part of this true policy of illegal settlement. It is therefore impossible to legally analyze this settlement policy without considering the specific measures deployed to realize it within the general context in which it is being applied and the effects it produces. The measures used to realize this settlement policy, taken individually, are problematic when it comes to the law which applies to the occupied territory. In other words, and in particular, international humanitarian and international human rights law. In this respect, Belgium has always condemned, in particular, the use of violence by the settlers against the occupied Palestinian population, and wishes to highlight Israel's obligation to put an end to the violence and to punish its perpetrators. More fundamentally, the policy of settlement aims to bring about an alteration of the demographic composition of the occupied Palestinian territory and its status as a territory itself. In this regard, this policy conflicts with various fundamental rights or fundamental rules rather of international law. I will successively walk you through the prohibition on the acquisition of territory by force, the right to self-determination, and the principle of non-discrimination. First of all, the settlement policy flies in the face of prohibition of the acquisition of territory by force. This prohibition is an integral part of the prohibition on the use of force, which is set out in paragraph 4 of Article 2 of the United Nations Charter. Resolution 2625/25 of the UN General Assembly, as well as paragraph A of Article 3, that is to say, the definition annexed to Resolution 3314/29, resolution of the General Assembly. Now, in its advisory opinion of 2004, your court confirmed the applicability of the prohibition on the acquisition of territory by force to the occupied Palestinian territory. This prohibition covers both the de jure and the de facto annexation. The measures adopted by Israel as part of its policy of settlement aim to create irreversible facts on the ground and to consolidate its control over the territory concerned by establishing settlements. These measures thereby create a situation in which a fait accompli, which resembles a de facto annexation, is brought about. Such a situation as defined by this court in the advisory opinion of 2004. Secondly, the settlement policy is inconsistent with the right of the Palestinian people to self-determination enshrined in the United Nations Charter and reaffirmed in the General Assembly's Resolution 2625/15, as well as the first article of the International Covenant of Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights of 1966, to which in the case of both covenants, Israel is party. Resolution 2625/15 specifies that the fact of submitting peoples to subjugation, to domination or foreign exploitation constitutes a violation of the right to self-determination, and that states have a duty to refrain from using any coercive measures that would deprive peoples of their right to self-determination. Now, in its advisory opinion of 2004, your court found that the right to self-determination had been violated. In doing so, it paid particular attention to the measures bringing about, and I quote, the departure of Palestinian populations from certain areas, end of quotation, and also paid particular attention to alterations to the demographic composition of the occupied Palestinian territory. Similarly, in its report published on the 14th of September 2022, the Independent International Commission created by the Human Rights Council and tasked with investigating or conducting investigations in the occupied Palestinian territory, including Eastern Jerusalem and in Israel, underlined that, and I quote, the choice of location of certain new settlements further reduces the likelihood of an end to the occupation and violates the right of Palestinians to self-determination, end of quotation. It follows from this, from what I have said, that the adoption of coercive measures in connection with the policy of settlement aims to alter the status and the demographic makeup of the occupied Palestinian territory, and that it runs counter to the right of self-determination. Thirdly, the policy of settlement raises serious concerns with respect to the principle of non-discrimination. Indeed, the establishment of settlements is intrinsically linked to the establishment of the two distinct institutional and legal systems, one for the settlement residents and the other for the Palestinian population of the occupied territory. The Independent International Commission of Inquiry, which was mandated to investigate in the occupied Palestinian territory, including Eastern Jerusalem and in Israel, as well as the Committee on the Elimination of Racial Discrimination, have underlined the problematic nature of the measures concerned with respect to the principle of non-discrimination. And therefore, and this will bring me to the end of this part of the Kingdom of Belgium's oral submissions, thus, the settlement policy is problematic with respect to the prohibition on the acquisition of territory by force, the right to self-determination, and the principle of non-discrimination. I shall now turn my attention to the fourth and final point in our oral submissions, and that is the legal consequences of the violations which we have identified and have been identified. I will start with the legal consequences for Israel before spending some time on the legal consequences for third states and international organizations. As an introductory comment, Belgium would like to underline the fact that that several of the rules mentioned before are Jews, Coggins norms of general international law. Consider, for example, the right to self-determination and the prohibition on the use of force, which includes prohibition on occupation and annexation of territory by force. Therefore, no circumstance excluding unlawfulness can be invoked to justify their violation. For Israel, the violations identified lead to consequences provided for in the customary rules of international responsibility, which are codified in the articles of the articles concerning the international responsibility of states, which were adopted by the International Law Commission in 2001. It is a matter of an obligation to end an ongoing violation, an obligation of reparation, as well as the obligation to provide assurances and guarantees of non-repetition. Specifically concerning the policy of settlement, with respect to the ongoing nature of the violation, Belgium refers in particular to Israel's obligation to end all settlement activity, as was affirmed in the advisory opinion of 2004, the obligation to make reparation should first and foremost take the form of restitution. In other words, inter alia, the dismantlement of the settlements, the annulment of legal acts concerning the settlement policy, and the restoration of property requisitioned or expropriated in carrying out this policy. This is also the option which is preferred in the Security Council Resolution 2334 of 2016. Now, as regards third states, their obligations are based on several rules of international law. In other words, rules relevant to the international responsibility of states. Also, the obligation to enforce international humanitarian law and the right to self-determination. Firstly, as regards grave violations of Cogan's norms of international law, the states must not recognize as legal the situation arising from the states must not recognize as legal the situation or a situation arising from a grave violation of a peremptory norm. States must not render aid or abet in maintaining the unlawful situation created by a serious violation of a peremptory norm, and must cooperate to end the violation. Secondly, as regards violations of humanitarian international law, the obligation under treaty law and customary law to enforce these rules is set out in the first common article of the 4 Geneva Conventions. This obligation also bears on third states, and it includes both negative and positive obligations. The obligation to not aid or abet the commission of a violation is an example of such a negative obligation, and the obligation to take measures to incite the warring parties to cease violations of international humanitarian law is an example of a positive obligation. Thirdly, a similar obligation bears upon third states as regards the right to self-determination. Indeed, Resolution 2625 provides that, and I would cite, all states have a duty to promote jointly with other states or separately the achievement of the principle of the equality of the rights of people and their right to self-determination. End of quotation. Resolution 2334 of 2016 provides a specific example of enforcement of such obligations. In that resolution, the Security Council calls upon all states to distinguish in their relevant dealings between the territory of the State of Israel and those territories occupied since 1967. Now, that call reflects the obligation to conduct dealings, including economic and trade dealings, in such a way that there is no recognition, no assistance, and no contribution provided to maintain the unlawful situation of the settlements. Finally, and this will be the last point made by the Kingdom of Belgium, the legal consequences associated to the serious violations of the peremptory norms that I have mentioned heretofore also apply to international organizations. Now, of course, international organizations operate within the bounds of their remits, but where they have discretion to act, they must exercise it to end serious violations of peremptory norms. Mr. President, ladies and gentlemen, members of the court, this concludes the oral submissions of the Kingdom of Belgium. I thank you for your kind attention.
I thank the delegation of Belgium for its presentation. That brings to an end this morning's hearing. The court will reconvene this afternoon at 3 p.m. to hear Belize, Bolivia, Brazil, and Chile. Hearing stands adjourned.
Rejuvenating media day by day. This is Salam Media.
Discover the Africa of your dreams and surround yourself with her spectacular beauty. Relax beneath her serene sunsets and explore wildlife at its natural best. It's where the pride of Africa comes together. The Kwantu Private Game Reserve. Get to know the Big Five or cruise on an elephant safari game drive. Interact with lion and tiger cubs and enjoy world-class halal cuisine while we pamper you during your 5-star stay. Indulge in the true African experience. For reservations, call now on 042-203-1400 or visit kwantu.co.za. The Kwantu Private Game Reserve, the place of gathering.
Africa.
The Amman School of Excellence in Lebanon provides world-class education to Syrian and Palestinian refugees and Lebanese children, with a library, coding robotics lab, special needs classroom, and more. Amman is the foundation from which a generation of underprivileged children can fight poverty and reclaim their freedom. Donate towards a child's education because every child deserves the chance of a better future. Africa Muslims Agency, empowering, educating, inspiring.
World-class financial services only at Sapphire Global, your financial partner. If you are looking for Islamic Sharia and ethics, look no further. Sapphire Global offers a wide range of financial service offerings from short-term to life